Hi, everybody. I thought during quarantine I might present you with some information about the importance of estate planning and just talk about some of the different documents that you might need. My name's Travis Defoe. I'm an attorney. My office is in Frankenmuth, Michigan. I'm going to put this on my YouTube channel and on Facebook. If you email us, I can, and there'll be a link below. I can send you copy of the PowerPoint that's going to be used in conjunction with this, and a couple of checklists for you to look over. So let's get started right away. There's two main reasons to do estate planning. One is to plan for a disability. Whether we're talking about Alzheimer's, dementia, a stroke, MS, something that is going to put you in a position where you're going to need someone's help in handling finances. And the other reason is to make medical decisions, especially end-of-life decisions, and that's another document that is part of your estate plan. And then the second reason to do an estate plan is so that you can decide how everything is to be divided upon your passing, and to make sure that everything is easily set up for your heirs and a smooth transition for them. So the question is, what documents should I have? So let's start out and just go through those documents. First, the healthcare power of attorney. So in this document, you name someone who can make a medical decision for you. This can be anybody that you choose. Oftentimes it's a spouse and then children, but it can be a friend. It can be anybody. One of the things that we include in our medical powers of attorney is discussions and empowering that person to make decisions at the end of life, whether to stop artificial treatments, ventilators, things like that. The things to keep in mind about this document is that, number one, it isn't effective until you're unable to make any decisions. And number two, is that the person who is making the decisions, the person you appoint, their judgment and the particular situation is what is going to sort of make the decision at the end of the day. So usually we talk about not only trying to put in writing what it is you want, but having a conversation with the people that you appoint. The next document is a financial power of attorney. This document can either be effective immediately or can be effective upon disability. It would allow the person that you name to open a bank account, to take money out of a bank account, to pay bills, talk to the IRS. And again, this person is usually, the first one we name is usually a spouse, and then we have children, although there's other people that can be named as a financial power of attorney to effectively make whatever decisions need to be made at the time that they need to be made. One of the common situations that we use this for is in conjunction with people who have trusts. Sometimes we will the funding won't have been done, and so this document would allow your loved ones to make sure everything is placed into your trust before you pass away. The other document that people would have is a will. And in the will, you're going to do a couple of things. Number one, you're going to name a personal representative. In TV and in other states, it's called an executor. This is the person that's going to guide things through the probate process. If you have minor children, we name a guardian in this document. That would be the individual that would take care of your children should you and your spouse pass. A will is a one-time event. It is effective at the time of death, and it requires probate. It has to go in front of in the state of Michigan, a probate clerk to give authority to the personal representative to act on your behalf. Even if we're doing a will, we oftentimes will do a trust, and a trust is different than a will in a couple of ways. As I just mentioned, a will is a one-time document, whereas a trust is essentially effective, and the trustee, sort of the personal representative or the financial power of attorney in the trust, is empowered to act immediately. So usually when we draw up a trust, we are drawing it up for Joe Smith, and we name Joe Smith as the trustee. But it will also allow for the naming of successor trustees to, again, take over if there's a disability. And this is probably the one place where the maybe overlooked place where a trust is most beneficial. Financial institutions, real estate title companies, everyone is getting more and more comfortable with trusts, especially in Michigan with the trust code. So they are willing to work easily with the trustees to accomplish whatever goals are needed. But then the other situation is it will continue after you pass, and you can leave direction either to have things distributed immediately, similar to a will, or a trust also gives you the flexibility to divide the money and pay it out over time, especially if there's some concerns as far as spendthrifts or children who might not be used to managing that large of amounts of money. It can make it easier if they're receiving it in smaller chunks over time. So if you already have those documents, are you done? Well, maybe, but it's oftentimes good to take a look at them and determine whether or not they need to be brought up to date. A lot of times people, when they have children, they will create documents, and then 20 or 30 years later, those kids are grown, but they still haven't updated their documents. So if you did your documents when your children are minors and they're no longer minors, that's probably a good reason to take a look at whether or not some changes need to be made or the documents need to be updated. And one of the other reasons might be the people that you named as trustees, personal representatives, financial powers of attorney, medical powers of attorney. Maybe they don't live in the area anymore. Maybe they've passed away. Maybe you now want to have your children instead of them named. Any of those reasons would justify potentially redoing them. The other thing is that, honestly, Michigan law, especially as it relates to trusts, had a major change in 2010 with the advent of the Michigan Trust Code. It's not that the trust code would render trust prior to that time completely ineffective. It's just that there are certain things that we can do now that maybe we couldn't do before, or things that are more straightforward than they used to be. One of the other things is that the estate tax with the federal government is now pretty high. So for an individual, it's $11 million. If you go back from the middle of the 2000s, I think 2010, the estate tax was zero, and then it was, after that, I think, bumped to $5 million, and it fluctuated somewhere between $1 million and $5 million over the course of the early 2000s. And a lot of people did what are known as AB trusts, or a credit shelter, not a credit shelter trust, but a estate tax maximizing trust, so that you could maximize the trust, or the estate tax exemption for you and your spouse. These are no longer really needed, depending on the size of your estate. Obviously, bigger estates, it may make sense to still have them. But if you're under $5 million, you probably don't need them, because with the estate tax exemption at 11 doubling to 22 million, it's unlikely that you are potentially going to be into that threshold. So it affects a lot less people. But the other big reason is that the IRS passed a regulation that now allows you to merely file a federal estate tax return at the time of the death of the first spouse, and it automatically gives the second spouse a $22 million exemption, or the double exemption. So there's no reason anymore to have the AB trust. Another reason to reevaluate your estate planning documents would be any changes in the life or the life of your children. So maybe you did the estate planning documents when your children, one of your children was married and now they've been divorced, or any other thing that can cause change in circumstance for those children or the people you have named as beneficiaries. The other thing to think about is whether or not you've moved states, whether or not you've gotten divorced, adopted, or had a child, received a promotion, demotion, changed jobs, have additional property. And this is a place where it's probably important to stop and talk a little bit, because with trust, one of the most important things, if you have a trust, is that the trust is funded. And the term funded in this situation means that the items have been placed into the trust. So we're talking about, has a deed been drawn up that transfers your house from Mr. and Mrs. Joe Smith to Mr. and Mrs. Joe Smith, trustees of the Mr. and Mrs. Joe Smith Trust. The other thing, though, that we need to do is to make sure that the bank accounts are either in the name of the trust or have a beneficiary designation on them. And the same would apply to 401ks, IRAs, and other things, other financial accounts. However, there is a caveat in that we generally look on an asset-by-asset basis to determine what is the most effective way to transfer the money from you to your children. So, especially in light of the more recent changes that will limit a IRA or other qualified accounts to a 10-year distribution chain or distribution. It used to be that you could roll them over and they would be able to go on for the life expectancy of whomever the beneficiary was, and that's no longer the case. But nonetheless, we would want to look at who's the beneficiary on that account. Is it the right beneficiary, or do we want it to pass through the trust? And there's other personal property that usually can be assigned to the trust. Land contracts can be assigned to the trust. Other things would, business interests should be assigned to the trust. But basically what we're talking about is just reviewing all the assets to make sure that they're properly titled for your estate plan. Because if they're not properly handled, then the estate plan isn't going to work at all. The trust isn't going to work. We're going to, without a properly funded trust, you're going to need the will, and you're going to have to go through probate, which obviously one of the main reasons I hear people wanting to have trusts is to avoid the probate process. They've gone through it. They didn't find it to be the greatest experience. The bureaucracy of it, the time that it took. Trust can sometimes simplify a lot of those things. And so if your trust isn't funded, frankly, we're back to square one, where we're going to, you had a trust, but we're still not going to avoid probate. So the next thing, so what should you do? Well, again, seeing how we're in quarantine right now, and in Michigan at least, lawyers haven't been deemed essential, and nonetheless, it probably is hard to meet with an attorney with the 6 feet social distancing. So one of the things our office is offering is either telephone consultations, or we can do video conferencing as well, either via Zoom or FaceTime, or we've used Facebook Messenger. There's a number of different ways that we can attempt to connect so that there's more of a face-to-face connection with our clients. And very recently, one of the last executive orders signed by the government now allows us to execute those documents remotely, so that they can be notarized essentially over the same video as we're talking about having that meeting. So I guess the next thing to do would be shoot us an email. My email is Travis, Travis, at frankenmuthlaw.com. And we will send you the documents that you need, whether it be the PowerPoint or the checklists. Just let us know that you're interested, and we will send those to you. If you want to make an appointment, again, you can call our office number, which is being answered still, 989-321-2330, and they can schedule you with an appointment, or schedule you with a quick telephone consultation to see if there is something that we can do to help. So with that being said, I hope this was informative, and I hope everyone continues to stay safe and keep their social distance from everybody else until this is over. But please let us know if there's anything we can do to help. Thanks.